First article of business this morning before we call our first witness is a motion that we filed in regards to a previous motion in limine that had been done. It has to do with an expert's ability to rely on a statement made by an authorized agent of another party. In particular, in this case, it's the liability experts that were retained by the two sides. We have a liability expert who is prepared to testify today regarding similar topics and areas of expertise as another expert that plaintiffs had retained. The issue in this case is Mr. Barth, the defense expert's ability to rely on the analysis and statements of Mr. Tamaris, an expert that was retained by plaintiffs but was withdrawn just prior to trial. At issue is Mr. Tamaris' expert opinion that removal of a peephole back in 2008 was not foreseeable in the hospitality industry. Now, there was a motion filed by plaintiffs to exclude that. The court granted that, but at the time it was granted, we made the court aware and the parties aware that should we be able to find authority for that to be admitted, that we would raise this issue again. Your Honor, we've submitted our motion and assert that we found just such authority. They are under the applicable rules of evidence. We start first with what can an expert rely upon. 702 and 703 make clear that an expert can rely on a statement that's otherwise not admissible. That would include a statement of someone else who has training, expertise, and knowledge of that particular field. Mr. Tamaris was disclosed as by the plaintiffs as a hospitality security expert who was expected to talk about the reasonable standard of care and best practices of hotels in September and August of 2008. During his deposition, he opined, per his expertise and knowledge, that the removal of a peephole, such as what occurred in this case, was not foreseeable. Mr. Barth, the defense expert, has relied on that statement as part of his foundation and his own independent analysis of the foreseeability of that very event. So he can rely on it under 702, 703. The next is, can it be admissible? Your Honor, we would assert it is admissible under 803, the hearsay exceptions, because it is an authorized statement by an authorized agent of a party. Ms. Andrews and her counsel retained Mr. Tamaris as her agent to speak on these topics because they require expertise. Having retained him and authorized him to provide opinions, his opinions are authorized admissions of Ms. Andrews. For those reasons, and we've cited a case, unfortunately, there is not a lot of case law on this issue, but the only case we were able to find is actually a Fifth Circuit case. It's not a Tennessee case, it's not a Sixth Circuit case, but that doesn't mean it is not without authority. It is based on the same rules of evidence that Tennessee adopted. Tennessee adopted the federal rules of evidence to a large extent, renumbered them, wording slightly different in certain aspects, but the gist of 702 and 703, whether it's Daubert or CSX, and then under 803, the exception, which falls under a different rule number in the federal rules, are essentially the same. So we would assert that this Fifth Circuit case provides clear on the pleadings, the rules of evidence, and the expert disclosures in this matter. We would assert that Mr. Barth can rely on that and can testify that as a basis of his
Eight, 2015. For that, because Mr. Tamaris has not even been deposed yet. He was deposed on October 13, 2015. So Mr. Tamaris' opinions in his deposition were never relied upon by Mr. Barth in the formulation of his opinions. So that's one of the problems with their position. The deposition of a witness, whether or not a party, may be used by any party for any purpose if the court finds that the witness is unavailable. But depositions of experts, taken pursuant to the provisions of the discovery rule, may not be used at trial except for impeachment of the witness. He's not going to be here. The only purpose, the only proper authorized use of a discovery deposition is to impeach the witness if he's here. So they can't do directly what they're trying to do, and they're trying to do it indirectly. They're just trying to say that that person, unknown, who gave an 8-hour deposition, who got tired and made this statement, they're just trying to get it in that way. And he doesn't need it. They have experts to give their opinions. They don't need this. It's not like he's the only person in the world. So the motion should be denied. Thank you, Your Honor.
Your Honor, the only point that I would make in response to that is it wouldn't be contained in Mr. Barr's expert disclosure because Tamaris hadn't been deposed, and he announced his opinion for the first time during his deposition. You can't disclose something that you don't know about. Upon receipt of his deposition transcript, we provided counsel and we provided the court with confirmation that Mr. Barr did review that and did rely upon it in forming his opinions. Plaintiff's counsel has had the ability to depose Mr. Barr on those topics. It's a foundation of his opinion and should be allowed in.
Okay, the court will deny the motion under Rule 3201(3). Next.
I call Mr. Barth. We need to discuss with him what he can't do by the court order.
5-minute recess.
That's super.
All right.